thank you again for joining me today. I really appreciate you taking some time to learn about trusts and really learn about how to not only protect yourself, but even to protect your family and just what options there are for you. So one quick question was, are we automatically muted? The answer is yes. I cannot hear you, but hopefully you all can hear me. So again, though, if you have any other questions or anything, please do put them in the chat and the Q&A as we go through. So like I was saying, we're really focusing on protections, yes, for you, but really for the whole family, and looking at how do you protect those things or people that you love the most, but also how could they potentially protect you if you're at the point that you can no longer advocate for yourself. Before we get started with all of the legal components and all of that, let me go ahead and introduce myself to those of you I have not had a chance to meet yet. My name is Victoria. I am one of the estate planning attorneys with the Koppenberger Law Firm, and I primarily work in our Northern California offices. You'll see in just a couple of slides that we actually have offices all over the state. And so if you are not in Northern California, have no fear. Odds are we have a location in an area at least near you, if not specifically where you are. So first and foremost, let me introduce you to our team if you don't know us already. So we have quite an impressive team of attorneys. We are one of the largest estate planning firms in not only the state, but actually in the country. And a large part of that is because we have more than one department. A lot of estate planning firms are focused on estate planning. And for those of you who don't understand the difference, estate planning is essentially the foundational portion of making sure that you and your loved ones are protected during incapacity or even after somebody has passed away. And so that's a lot of times the meat of what we talk about in these webinars. But we do have other departments that are there to help you if you find yourself in a situation that goes a little bit beyond true estate planning. One of those departments is headed by attorney James Kosareff, and that is our estate administration department. This is the department that would be there if somebody has passed away and you need help on what comes next. What do I legally need to do and know about? And then what practically do I need to know about and do? And so James and his team are there to make sure that not only are your questions answered, but a lot of times to make sure that the work is done on your behalf so that you don't have to be stressed out about making sure all of the I's are dotted and T's are crossed. That is what we are there to do. Then we also have a business and tax department. Within that department, there's a lot of question often about how do I protect rental properties, or hey, I have a business. Is there a way that I need to structure it to protect myself or my assets in the best way? It could be I really am wanting to reduce the taxes I'm paying. Is there a way that we're able to do that? Anything that goes into business protection and tax components, we can also address in-house. And so that is one of the reasons we are so large. But of course, if we have that many departments, we also need this amazing staff to allow us to do everything that we do. So part of why we are so large is we have one of the largest staffs that estate planning law firms see. And again, the reason is to make sure that we can properly and adequately address all of our clients' questions and concerns in a timely manner. One of the biggest complaints I hear from people who have worked with other law firms is, I never heard back, or if I did, it took them months or sometimes even longer to actually get a response. And so part of how we are able to add such an amazing value to our clients is the fact that we have this team that lets us get you responses in a quarter, if not less the time than many other firms are able to do. And then I mentioned that we have numerous offices. And so again, if you are not in one of our specific areas, the good news is we can also do Zoom meetings and telephone calls. But for many people throughout the state, these offices are at least in their general area, or maybe in their family's area. So for some people, they're concerned that, okay, I've already gotten everything set up, but what if my children need to come and see you if something happens? Where can they meet you? Well, again, we have offices all over the state and we just keep expanding pretty much every year. And so again, if you have somebody who is in one of these areas, the good news is we can help them as well. So now let's dive into what are you actually going to be hearing about today. So when we say I love you with a trust, the reason we are so focused on that today is not only is it Valentine's Day month, but it's also such an important component of how you can say I love you to your family or whoever is going to be in charge when you are gone. Not only is providing protection for yourself, but it also relieves a huge amount of stress and question for your loved ones who are there to pick everything up when you no longer can. And then the other side of that is you can also provide protection for your loved ones, either while you're still living or after you are gone. And then ultimately, how do we leave a legacy? One of the reasons this firm was started, and one of the main reasons it is continued, is because we genuinely believe that every single person has a legacy that matters. And within that legacy, there are so many ways that estate planning can help to make sure it carries on for generations and ensures that your wishes are ultimately carried out, again, even if you're no longer with us. So we're going to go through a lot of information today. I do recommend that you take notes. That way, if or when you set up a consultation, you know what we had talked about and what triggered some questions that you would want specifically answered. Now, and I'll say this again at the very end, because you are watching this video, you are actually entitled to a free consultation with us. So whether you're brand new to Kopp & Barger or you're already a client in need of a review of your documents, you would get a free consultation to address whatever your needs would be. So first and foremost, let's look at the essential documents that every single person needs. These are documents that if you're over 18, you need, and if you have loved ones over 18, they also need. And those two main ones are the Advanced Healthcare Directive and Durable Power of Attorney. These are the documents that are there to ensure if you are incapacitated, someone can make medical decisions on your behalf and continue to manage financial matters on your behalf. But then for many of you, those are not going to be enough. You also need to start looking at, do I need a will or a trust? And for those of you who have not gone through this process before, you will hopefully have that answered at the end of this webinar. So first and foremost, if you are over 18, you need an advanced healthcare directive in place. The reason is that nobody, not a spouse, not a parent, not your child, has any automatic right to make your healthcare decisions. If you are unable to give verbal authority to a doctor that somebody can do an act on your behalf, you have to have it in writing. Otherwise, legally, the doctor is not able to talk to anybody who shows up, whether, again, it's a spouse, a parent, a child, or somebody else. They need to have actual authority in writing or verbally to be able to act for you. So if you have not put it in writing and you are in a position where you can no longer give that verbal authority, you're going to be left extremely vulnerable. These are situations that can be very, very easily avoided and overcome simply by having this advanced healthcare directive in place. But beyond that, having this directive in place can add such a level of peace to your family when they are having to make really hard decisions at the end of your life. A great example of this was actually in my own family. When my grandma was at the end of her life, we had to make the decision of, would she go on to any kind of machine to keep her going. And I already knew ahead of time she did not want those kind of measures taken. She did not want to be put on machines that would prolong her indefinitely. And so because she had already made that decision and it was already made in writing in her directive, it gave me a lot of peace knowing I just needed to carry out her wishes and verbalize what she had already decided. So I didn't have any guilt or question as to whether she would want those measures that would prolong her indefinitely. And so again, this is not only protection for you, but it's giving your family or whoever's making that decision a lot of peace of mind, knowing you had already made it and they just need to carry it out. And then the other side of it is, okay, now we've taken care of who would actually advocate medically for you, but what about the financial components? That's when we're looking at the durable power of attorney. This is the document that is there so that, again, if you are incapacitated, you have somebody named who can actually go in and manage your assets, make sure if there's a legal document that needs to be signed, that it can be, to make sure your bills are continued to be paid, and just generally that life is running, even if you can't do it yourself. Again, this not only ensures you are protected and your life can continue running, but it ensures that the family doesn't have to scramble to figure out, okay, now what? How do we make sure bills are paid? And how do we access the money? Do we need to pay out of our own pockets now? It gives them exactly what they need to make sure things run as smoothly as possible. So for both of these documents, if you do not have them in place yet, regardless of what else you end up doing from an estate planning side, these are the two to make sure you have in place without any question. And it's something that if you already have them in place, but have not had them reviewed in 3 to 5 years, I would strongly recommend coming in and having them reviewed. What we have seen in the last couple of years, especially in light of COVID, is a lot of people change their minds on certain decisions that are within the medical and financial powers, and they have decided to name different people to serve in those different roles. And so if you are in that position where you have one, but it has not been reviewed, I recommend at least come in and let us look through it so that if worst comes to worst, we make sure it's updated. And at best situation, we give you peace of mind that you leave and say, nope, I had exactly what I needed and now I don't have to worry about it. So again, either way, I recommend coming in and giving us a little talk. Then we get into, okay, do I need a will or do I need a trust? Well, with your will, you would be under a will if you have no real estate or if you have less than $184,000. The reason these two components are so important is if you own real estate or have more than that $184,000, a will is not going to protect your assets from what is called probate. Now I'm going to pause for just a second, and I am going to call out though, if you are the parent of a minor child, you need a will regardless of those other two parameters. And the reason is that in your will, that is where we name the guardians of your kids. So if you have anyone under 18 in your household, you absolutely need a will in addition to those other two documents. But as I mentioned, if you have real estate or more than that $184,000 number, the problem is that your assets in your estate would have to go through what is called probate after you passed away. Probate is there essentially to determine, are there any outstanding debts that you owed? Did anybody owe you any money? How do we make sure everything is cleaned up? And ultimately, where is the money going to be transferred? That is what the court will determine if you have a will, but you have real estate or more than that $184,000 number. Probate is something that we absolutely encourage every single person to do their best to avoid, because anytime you are dealing with the court, and frankly, anytime you're dealing with a government entity, generally speaking, it's going to be extremely lengthy and very delayed and very expensive. The average probate that we see lasts anywhere from 2 to 5 years after it has started. And so what that means is your loved ones, your family, your friends, whoever is invested or involved has to wait 2 to 5 years to have everything settled and ultimately distributed. So in that 2 to 5 years, no one has inherited anything and they have to continue waiting for the court to ultimately decide where things are going. I also mentioned that it's extremely expensive. If you are curious about what that cost would be, and I'm going to put it in the chat actually, go to our website, which is just www.koppenbarger.com, and go to our resources tab. Under that tab, there is a probate calculator. And on that calculator, it will ask you to put in what is called the gross value of your estate. So not what your equity in your home is, not what you have from that standpoint, but what could you sell that property for? What is the gross value of your estate? When we're asking about your estate, that's again, gross value of any real property. That's cash, that's stock accounts, that's your money. Put that number in and see what it spits out. Generally speaking, if you just owned a home that was gross value worth $1 million, you would be looking at about a $40,000 probate bill that could actually be higher than that at the time. So just to go through probate, they could be sucking $40,000 out of your estate to cover the fees, to frankly cover the attorneys. And there may be actually a $60,000 bill if the person who has had to deal with the court decides to take an equal portion to the court and the attorney. So it can be extremely, extremely expensive to go through probate. And so our goal again is to make sure that everybody avoids that. So how do you do it? The great news is that just by setting up a trust and making sure that certain assets are in that trust, you can avoid the hassle and headache that is probate. With a trust, it's essentially a contract that you are setting up. What that means is you set the who, the where, the what, the why, the how. So you're going to determine all of the terms that are in that trust. You are the person creating it. So you are generally known as a settlor. That again is just a fancy way of saying creator. You will also determine who is going to serve as a trustee if you can no longer manage the assets. So who would that person be? It could be your children. It could be, if you're married, it's often your spouse. It could be other family, friends. It could be a private fiduciary. It's whoever you feel would be the best person or people to manage your assets if you no longer could. And with being a trustee, it is someone who has to follow the terms of the trust. So when we're thinking about who should serve in this role, generally we recommend to make sure it is somebody who's responsible, that they remember to pay their own bills on time, and that ultimately they will carry out your wishes. If any of those things make you question the person that immediately came to mind, it's likely not the right person then. Because again, being a trustee is a job, and they need to make sure your wishes are ultimately the ones carried out, not their own. And then the last portion is, okay, if you have passed away, who actually gets to benefit from the estate that you have built? Who is going to inherit those assets? When are they going to inherit them? How are they going to be able to use them? You can get extremely detailed with this, but again, that's in your control and in your hands. So why would you want a trust? Well, the biggest reason is to avoid the cost and delay of probate. That is a huge piece of why our clients who set up trusts ultimately set them up. They don't want their family to be stuck in probate for 2 to 5 years, and they really don't want the government to be claiming any extra money than is absolutely necessary. And so that is a huge motivator. But there's a lot of other components that go with a trust. For one, it ensures your privacy is protected. Anytime something has to go into court, it generally is going to become public knowledge. And so with a trust, it doesn't go to court and it stays private. It also allows you to plan for future generations and have protection around them and their inheritance. That is not something that happens in court. And so if you are concerned about protecting your future generations and ensuring that the inheritance stays in your family rather than going elsewhere, there are things that we'll talk about today that you can actually put in place to accomplish that. If you are concerned about taxes, I mentioned at the beginning, we have a business and tax department. There's a lot you can do within your estate plan to ensure that taxes are, if nothing else, reduced, but in most cases completely eliminated after you pass away. And so that can be a very large concern that our clients have that, again, we can address. Another big one is avoiding what's called a court-supervised conservatorship. Essentially, what that means is you did not put into effect any of these estate planning documents. You have now become incapacitated, and the court is having to determine who's taking care of you and who would take care of the finances. So again, we're looking to avoid the court there as well. But ultimately, our entire goal with all of this is ensuring that your wishes are the ones carried out and that your family remains protected no matter what has ultimately happened to you. But one of the issues with a trust is that it only protects what it owns. And so we also create what is called a pour-over will that accompanies your trust. So even if you have a trust, and whether or not you have guardian children, you will also have the guardian, for your minor children, you will also have a will. The reason is, as I mentioned, a trust only protects what it owns. What that means is just because you have taken the wonderful step of setting up a trust doesn't mean that your job is done. We take care of when you come in and meet with us, making sure that your properties in California are transferred into the trust. So we do that as part of our service. But there are other pieces that we unfortunately can't at this point be involved in. That includes making sure your checking, savings, money market accounts, non-retirement stock accounts, things of that nature are actually put into the name of the trust. And so if this has not been done at the time you pass away, we've created this will to tell a court, don't let that asset go through a full probate, give it back to the trust. It still requires us to go to court once, but it keeps it from going through the entire probate process. And so it allows everything to ultimately go back to your trust and then go how you've wanted it. But this is not a step we want to have to take. And so, especially if you already have a trust and you are not sure if you have properly put assets in, do come and talk to us. We are happy to make sure that this is a step that was properly done to make sure that, again, nothing has to go through court when you are no longer here. And then a part of what we do is not just the financial, not just the looking at how to protect the money, it's also looking at the emotional side of things. So for a lot of people, this is a large part of the conversation we end up having. It's, what are your burial instructions? What do you want done with your own body once you are no longer here? That can, again, not only give you peace of mind that what you want will be carried out, but it also allows the family to have in writing what your wishes would be so that they don't have to guess. The other big portion that we talk about is what to do with your personal property. Unfortunately, personal property, despite the fact that often it doesn't have a whole lot of monetary value, is one of the areas we see a lot of fighting after somebody has passed away. The reason we see fighting is people are fighting over the item because they now have an emotional attachment to it because their parent or their loved one is no longer here. One of our worst fights we ever saw was over a pasta colander. And I'm not kidding when I say that. We had 3 beneficiaries that all really wanted this colander because it is what mom had used during holidays and for birthdays and pretty much every special event to cook the different meals in or to strain it after it had been cooked. And this was something that probably during life, they didn't really think twice about. But as soon as their mom passed away, that all of a sudden had an emotional value to them that really didn't have any monetary value, but was something they were very willing to fight for. That is something that could have likely been avoided had there been a letter saying, maybe share custody of it, that each of you gets it for the different holiday. Whoever's going to be hosting that year is going to have possession of it. Anything could have been done where you actually can put in writing who gets the item and even put parameters around it. And then in other situations that aren't quite that extreme, it can just be that somebody has an emotional attachment to an item and you just want to make sure that they're the one who inherits it. And so we've put a power in your trust that actually says all you need to do is in your handwriting, say what the item is, who it goes to, and sign and date it. It doesn't need to be witnessed or notarized. And so it allows our clients to have a lot of flexibility and control over where their stuff ultimately goes. And then once they're gone, can reduce a lot of the fighting that we often do see. So again, if these are any questions that you have, if this is triggering anything that you go, oh, no, I really do need to discuss this further, again, please come and see us. So now we've talked about how to protect you, but now let's look at what other options you have for protecting your beneficiaries. So if you have minor children, it is so important to make sure you have some kind of a will in place that would name who the guardians of those kids would be. But a lot of times the big question is, well, who should they be? Parents don't like to think about what happens if they're no longer here and their kids are still minors. But this is such an important thing to go through and really make sure you are as close as possible naming somebody who can carry on what your wishes for your children would be. So who should they be? Well, a lot of times when we're looking at that, we're talking about what is just generally their personality. Are they financially savvy? Do they have kids? This is a big one, because if you're the person that you would want to name, let's say, has a 15-year-old and you have an infant, is it fair to ask them to not be empty nesters for an additional 15 years after their child is out of the house? So that is something that can be a big part of the conversation. What are their morals and values? Do they have similar morals and values to you? And then a big one for a lot of clients is, what is the religion that you would want the kids brought up in? Maybe you don't want a religion brought up, and so it may not be something that you then want to involve the guardians for. Maybe you're the exact opposite. You really want them to be raised in Christianity, and that is something that's a non-negotiable for you. It's probably then wise to try to at least pick guardians that, if they're not already Christian, would be willing to take your child to church or do the things that you would want to do. So these are some of the things, as you're going through, who should my guardians for my kid be? These are some of the things to consider and think about. But then there's another piece of it. What happens if your child turns 18? So you've passed away before they were 18. You've had the guardians in place who have custody of them, but now they've turned 18. Are they at a point that they would be mature enough to actually receive their inheritance and go off and manage it? Most of the time, when I talk to parents about when they would want their kids to actually have control over the inheritance, they do not want it to be anywhere near the age of 18. Because for most people, 18 is not just because you became a legal adult, it is not when you necessarily became mature. And so that's where, within your trust, you can also put in what are called minor's trust provisions. This essentially is there to manage and protect the assets for your child and provide instructions to the guardian, and can last well after the age of 18. So within these minor's trusts, we see some people say, my child could actually manage their own inheritance at the age of 25 or 30 or 35. Some people say, well, at 25, they could probably manage a quarter of it, but then the next quarter shouldn't be in their control until they're 30, then 35, and then 40. So you can set whatever parameters you want around your minor's child's inheritance and when they actually, again, have control. It doesn't mean that it can't be used for them until that age. It just means they don't have the keys to the account to potentially run off and spend it in maybe some frivolous ways. Again, this is all to say that you can continue protections to whatever extent that you need and want them to be done. And then for others of our clients, they don't have minor children anymore, and now they're looking at, okay, I don't have the legal ability to dictate everything my child does, but it's still my child despite the fact that they are an adult. So how do I protect them even after they've become an adult? And the good news is there are protections that are absolutely available for your adult children as well. We call these typically protective lifetime trusts. That's the common name that we use. These lifetime protective trusts actually protect their inheritance against divorce, lawsuits, creditors, bankruptcy, and even the IRS. Essentially, what it means is your child can still receive their inheritance. It just goes into the form of a trust that keeps any outside predators from getting into it. So this can have extremely lasting benefits, not only for your child, but it actually means that when anything passes to future grandchildren, it would pass free of tax. And so this is a multi-generational tool that you can put into place to last long after you are no longer here. So if you have any concern about how to protect your adult children, and make sure that whatever life throws at them, they would have this safety net of an inheritance that could not be taken from them, come and talk to us about these protective lifetime trusts. So then we start looking at, okay, I still want to protect my kids after I'm gone. We've talked about the protective lifetime trust, but what happens if I'm married, I now have passed away, and my surviving spouse remarries? What if they decide they want to give the estate to this new spouse or new family? How do I make sure at a minimum my part of the estate goes where I would want it to go? That's where we start talking about what is called an AB trust. An AB trust is one that actually allows your half of the estate to be protected from remarriage and ensures that it ultimately goes where you would want it to go. I'm not going to go too into the weeds on this right now because it will not apply to everyone on this call. But if you are married and have concerns about remarriage protection, if you were no longer here, absolutely come and talk to us about this AB trust. So now we've talked about how to protect you, how to protect beneficiaries, but what happens if you are alive but now have become incapacitated? We're going to go back to how do we protect you, but also how do you make sure that your family has the tools necessary to not only take care of you, but to reduce stress that often comes due to incapacity and conservatorship issues. So in this first slide under incapacity, we're really focusing for a second again on the emotional side of things. Anytime you are dealing with someone going into some kind of incapacity, it's going to unfortunately increase stress. It can increase guilt on the family's part, and it can lead to more frustration because a lot of times whoever has become incapacitated is probably frustrated that they don't have control. And the ones caring for them often have frustration because the person is not always the most agreeable when it comes to decisions that need to be made. One of the biggest points I want to call out on this slide is the one about paranoia or suspicion. One of the first warning signs we often see, and that they have done research on when it comes to Alzheimer's and dementia, is that an early warning sign is paranoia, suspicion, and even anger. And so if you notice a loved one is all of a sudden not acting as they normally would, they're questioning things, they seem suspicious, there's outbursts, there's even sometimes violent tendencies, these can be early warning signs that you should probably, if possible, have them go to a doctor to get checked out to see, are they starting to show signs of Alzheimer's or dementia? So that's a big one that, again, we've seen time and time again, and just want to make sure is flagged so that you are aware and can help other people be aware so that it can be caught as soon as possible. But part of why we're also talking about this is we understand that when we're dealing with incapacity, it's again, not only looking at how to protect you, it's also looking at who should that person be and how do we make sure that they actually have the tools necessary to take care of you. So going all the way back to the very beginning, if you do not have the appropriate documents in place, primarily the healthcare directive and financial power of attorney, and have those documents in place and up to date, you could be at risk of what is called the conservatorship process. A conservatorship, again, is where a court is actually appointing the person who would take care of you and would take care of your finances. This, again, is something that could be very easily avoided with just those first two documents. But if we don't have them in place, this is where we receive calls from people and we're having to then go to court to have them appointed to take care of their loved one. Conservatorships, similar to probate, are pretty lengthy, unfortunately, and they are expensive. And to make matters worse, if you're dealing with someone who's incapacitated, it means your stress level gets to increase because now we have to wait for the court to give you the authority to take care of your loved one. So again, anytime we can avoid this, we're absolutely going to advocate you do so. So this is where I cannot hammer home enough that if you do nothing else, make sure you have those first two documents in place and that you make sure that they are kept up to date. One of the reasons those are also so important is because we are seeing the rate of illness rise. And so that is an absolute concern for seniors in our communities and just in our country. They are concerned that as they become ill, they lose control. And with loss of control, it is so important to try to retain it wherever you can. And one of the biggest ways that we are able to help clients do that is in the form of your estate plan. All right. I'm going to pause 1 second for a question. The question that we received is our trustee for financial the same for conservatorship if I get dementia? Do we list that in the trust? So If you have named a trustee or a financial power of attorney, you don't need the conservatorship. That is the person who would manage the finances. And it is then somebody where you would name them in the trust and the financial power of attorney. If you need a conservatorship, the person you would have wanted may not be the person that they name. The court essentially has a list of who they have determined makes the most sense to take care of you. And unless someone else can make a compelling case for why they should be the person, the court's going to follow their list. And so that is another risk with going to court, is they may not name the person you would want to. So putting the person you want in your documents ensures that that is the person taking care of you and your finances. That was a great question. Thank you. So again, as we're looking at incapacity and how do we protect you and how do we make sure your loved ones have the tools that they need, the reason, again, we are so focused on this is we just see the rate of illness and the rate of people with long-term illnesses rising at a rate we cannot keep up with. But then the other issue is, how do we pay for it? If we need more care, if we need care that lasts longer, and if you live in California, you often know that just everything keeps going up in cost. The next big question for the family and for you may be, how do we make sure that we don't go absolutely bankrupt in the attempt to pay for and care for our loved one? So there's a couple of different programs that a lot of people may have heard about, but may not really understand, that can actually help pay for this care. If you are in the state of California, the only two that you need to worry about today are Medicare and Medi-Cal. Medicaid is the program that applies to every other state, but does not currently apply to California. With Medicare, that's an age-based, essentially health insurance program. So if you're over 65 and you need health insurance, Medicare is generally speaking where you're going to look. But then what I'm really going to focus on right now is actually Medi-Cal. Most people are under the impression that they will never qualify for Medi-Cal because they are, quote unquote, too wealthy to qualify for that program. But that is actually not the case for most people. Now, I'm going to pause on that for 1 second. It is really important to understand that the cost of care in California is astronomical. These are the average costs across the entire state. If you are lucky enough to live in the Bay Area or in an Orange County area, San Francisco, any of these bigger cities, these are very, very conservative costs. Normally, you will see significantly higher ones in the bigger cities and areas. And so it's even more important to pay attention to, how do I make sure I don't completely deplete my estate in the attempt to care for myself or my loved one? So that's when we go back to, how do you pay for it? Well, if you were lucky enough to have an income every month that allows you to pay for that kind of care, that's fantastic. But most people's income does not reach the level of care that they would need. And even if it does, if you are married, you don't necessarily want to deplete all of the income caring for just one. You'd probably want money left for the healthy spouse as well. So then we look at, do you have enough in savings? What about, do I need to now sell my home? Can my family step in and care for me? Was I in a position where I had long-term care insurance that I had signed up for that is able to adequately cover it? Or do I need to now turn to government programs? So this is where I'm going to go back to Medi-Cal. Again, most people are under the impression that they will not qualify for Medi-Cal because they have too much money. So there's a couple of things to note on this. First and foremost, July of last year, the rules changed. It used to be that if you had more than $2,000, you were disqualified from Medi-Cal from a financial standpoint. But July of last year changed that to go up to $130,000 per individual who needs Medi-Cal. So if you are somebody who was previously disqualified or thought you could never qualify, keep in mind that, again, that amount went up drastically. What that means is you could now own a primary residence and have up to $130,000 in other assets. And so it greatly expanded the qualification pool for who could actually now apply and get onto Medi-Cal. So that's one. But the other thing that is actually extremely unique to Koppenberger is we actually have a trust that was created in-house that Medi-Cal has been upholding for about 15 years now, that actually allows you to keep your assets and qualify for Medi-Cal. So if you have more than $130,000, you still could qualify for Medi-Cal if or when you needed it. So that is something that if you are concerned at all about this component, please do come and talk to us. But then the other layer that people are often concerned about is, well, okay, if I use Medi-Cal, that's great, but aren't they just going to come after my family or my estate once I'm gone? The great news is if you have a revocable trust, which is what we talked about at the beginning, or this Medi-Cal trust, they cannot come after your estate once you're gone. So your trust will also protect against state recovery later. So that is a huge benefit to having a trust of any kind, to make sure that they cannot come after the estate or family once you're gone, and they cannot touch anything that you have. Again, if you have any questions on this, do come and talk to us. This is often a very complicated and very detailed discussion, and I want to make sure that you get any questions you have answered. So now I'm going to shift a little bit more, focusing on what happens after you've set up a plan. Is it able to just sit there and never be touched? Do I need to come in? How often should I come review it? What happens from a maintenance standpoint? So for most of our clients, we recommend that they come in every 3 to 5 years to have their documents reviewed. The reason is legal laws may change and your life may change. So let me first focus on the legal changes that have come into effect in the last, I would say, about 4 years. Over the last 4 years, we have seen a few things that have actually impacted the language that is in our documents. I'm going to work backwards on these. Proposition 19 is one that actually affects your primary residence and your secondary properties pretty drastically. It used to be that your secondary properties up to $1 million over the assessed value could be transferred to your children without having property taxes reassessed. That unfortunately changed back in February of 2021, that any secondary property you have that transfers to anybody is going to be reassessed. So unfortunately, that is something that is not going to be able to be changed at this point. But it also restricted your primary residence being able to keep your property taxes. Now the rule says that if you are going to transfer a primary residence to children, the only way your kids can keep your taxes is if they own and live in that property indefinitely as their primary residence. So the issue that we see is for people with more than one child, if not all of your children would want to own and live in the property, at least a portion of your property would still be reassessed. So what we can do is put in language that actually allows your kids more flexibility and ability to keep your property taxes on that residence. Again, I don't want to go too into the weeds because it will not apply to everyone, but if you are concerned about this, absolutely come and talk to us. The other thing that changed recently was the Secure Act. That essentially now says that if outside of a spouse, if someone is inheriting an IRA or a 401k, they have to take the entire amount they're entitled to within 10 years. There is language in our trusts that if you have one of our documents and have not had it updated since 2018, is going to be out of date and could cause some penalties for IRAs and 401ks. So it is really important to come in and make sure that that language is up to date so that your children or future inheritors are not paying a cent more in a tax than they would absolutely have to. And then probably the one that I'm going to stress the most is the Medi-Cal authority. So I just talked about a Medi-Cal trust. That is a trust, again, that allows you to keep your assets and qualify for Medi-Cal. But what happens if you did not actually set that up and are now in a position that you need long-term skilled nursing. You would need this trust and that protection, but you can no longer sign legal documents because of incapacity. In your trust and in your power of attorney, there has to be language in there that says your power of attorney could actually set that planning up on your behalf to make sure you could still be protected. We just had a situation in the last week where we had a couple come in. She was at the point she could no longer sign documents, but absolutely needed long-term skilled nursing, and they didn't have a lot of resources to be able to pay for the kind of care she would need. She was a perfect candidate for a Medi-Cal trust, but unfortunately, they did not have a power of attorney and a revocable trust that gave him the authority to set it up on her behalf. This is something that, again, could be avoided simply by having your documents up to date. So if you have not seen us in the last 3 to 5 years, do not hesitate to come in. This, if nothing else, is something that I would very, very strongly recommend you have updated to make sure that you never lose protection options in the future. And then what happens if your life changes? So life is exciting. It can have a lot of trials and tribulations and changes that go into it. With that, your documents often then need to be adjusted at some point during your life. We say that your estate plan has its own life cycle, and that life cycle follows yours. So a lot of times the changes that we see that trigger somebody needing to come in to actually make an update is when their minor kids become adults. This might mean that you need new protection around your kids' inheritance. It might mean that you want them to serve in the different roles now. It might mean maybe they're struggling a little bit, and so we need to talk about what other options are there to protect them in the long run. Maybe you got married. If you had first come to see us and you were single and now you're married, you might want your spouse in these documents and to do a joint estate plan. Or if you had done a joint estate plan and now you have gone through a divorce, it might be time then, and likely recommended, to actually split the estate plan and have your own set up for yourself. And now your ex-spouse is not included in it. Your beneficiaries may need to be updated. So if you had charities, maybe your charitable intent has changed. Maybe you're not as close with people you used to name. You might want to make sure that your pets are now included, that if something happens to you, who actually has the control and custody of your pets? So those are another set of changes we often see. And then a big one again is health changes. A lot of times with health, that is something that then we start looking at, okay, what advanced and more aggressive type of protections do we need to put in place? All of this is to say, this is why we recommend you come in every 3 to 5 years. With the 3 to 5 years piece, it really does ensure that we can capture and protect and make sure you're kept up to date as much as humanly possible. The people who are at the most risk of not catching these things are the ones that don't come in for 10, 15, and even 20 years. So it is really important to, again, make sure you stay in contact with us so that if nothing else, we can give you peace of mind that everything is good. And then going all the way back to, how do we make sure you leave a legacy? For some people, their legacy is very focused on the financial components. With the financial side, there is a lot that we can do, not only with the estate planning piece of it, but also with our network of other professionals. So if you are concerned about how do you make sure your investments carry on, or your life insurance plans are really what you need, or making sure taxes are as reduced or eliminated as possible, if there are things that we do not specifically do and you don't have a resource yourself, we have a phenomenal network of professionals that we can refer you to. And then for others of our clients, they're really focused on the emotional legacy. This is the piece that I feel like most attorneys don't spend the time on. It's not something that we frankly make money on. And so a lot of attorneys, they don't want to spend the time on this. They don't want to focus on this. But here at Kopp & Berger, we understand and we personally experience how much the emotional side of things impacts us, our families, and ultimately the plan that we put in place. And so we do focus on this. I can speak from personal experience that after my grandma did pass away, one of the best ways I could have been left a legacy from her was by receiving her recipes. All of my memories with my grandma somehow involved food. She loved to cook, she loved to feed people, she loved to go out to eat. She really loved food. It was a love language for her. And so to receive recipes that I can now make years after she has passed away and remember that this was something she had done with me and had taught me really lets that legacy for her continue. And so again, if you have any questions on legacy, both the financial and or the emotional, do come and talk to us. Do not worry about asking questions on the emotional side. We are more than happy to talk to you about this. So I mentioned at the beginning, we were going to cover quite a bit, and I'm sure I went through some of it quicker than you would have liked. And so first and foremost, these are all recorded and will be then on our website. And we have other actually videos that are similar on our YouTube channel. So if you ever need more information, if you want to watch this again, please feel free to do so. The other piece is that we cover a lot of this then when you come back for a consultation. So this is a lot of foundational information to make sure you have the necessary start to understand, at least to a degree, where you should be focusing next. But come in and talk to us. We will dive very much into your personal situation and answer your questions in depth. So how can we help? Well, the biggest way is ensuring that what matters most to you is planned and provided for. Your estate plan should be customized to you because no family is a cookie cutter or carbon copy of another. And so your estate plan should absolutely be custom and tailored to your individual situation. But it is so important to make sure that you do these things while you are alive and well, to make sure, again, not only are you protected, but to say I love you with a trust by making sure your loved ones have the tools that they need in place, not only to take care of you, but also to be protected once you are gone. And a great way you can do that, again, is by maintaining that estate plan. There are so many situations where somebody set up a trust and then never looked at it again. And it ultimately then leads to issues down the road because it doesn't match the current situation. So maintaining that estate plan, similar to maintaining your car, ensures that things do not explode, figuratively or literally, in the future. And then again, why should you ultimately work with us? Not only, again, are we one of the largest firms, but with that being said, we have an extraordinary amount of experience, not only for ourselves, but then for the people that are behind us doing and helping us do what we do. And so it is, whether you end up working with us or you want to go talk to other attorneys, it is so important to make sure that you are working with a qualified professional. Estate planning is not the time you want to start cutting corners and even cutting costs, because as our founder says, you do not know the cost of an estate plan until you actually need it. That is not then the time you want to find out, is it a good estate plan or does it have holes in it? You want to have the peace of mind knowing you have good documents that are going to be there when you or your family need them. I'm going to now pause. So I had mentioned at the very beginning that, again, by watching this, you are entitled to a free consultation. And thank you for spending some time with me. Feel free to reach out to us and we cannot wait to work with you. Thank you.